Your amazing support of Mr. Goldman and advocacy on behalf of all families victimized by international child abduction is something that I respect greatly. I'm sincerely grateful for your efforts and honored to have the opportunity to address this committee. My only son, Sage, was born May 14, 2007. Like many parents, I spent the months preceding his birth rearranging my priorities towards fatherhood and anxiously awaiting his arrival. I knew being his father would now be the most important role in my life. In 2008, amidst increasing signs that something was amiss with my wife, I was having serious reservations about the long-term viability of our romantic relationship. I was ultimately at a loss for what to do, while quietly and thanklessly maintaining the monthly work schedule to provide for my family. I tried not to read the writing that was, in hindsight, on the walls, and hoped our problems would somehow work themselves out in time, or keep long enough for me to be able to find the time and energy to deal with them effectively. Time was, however, not on my side. In June of 2008, 3 years ago, my wife falsely claimed there was a family emergency in Tucson, Arizona. The emergency involved her never-before-mentioned cousin, a 12-year-old who had gone missing himself, and whose mother was scared to go to the authorities for fear of being deported. Despite great discomfort, I didn't object to my wife going to Arizona with our son to see what she could do to help during this dire crisis. The only alternative I saw at that time was to take time off from my job at IBM to care for our son alone, while my wife went to help find her endangered cousin. Being the sole provider for our family, that, regrettably, did not seem feasible to me at that time. My wife went to Arizona with our son for what was supposed to be a few days. Once there, she turned off her cell phone and only sent me occasional emails saying she was in Arizona and continuing to work on this family emergency. I didn't know what was really happening. Was my child suffering or in danger? The idea that my son might be in trouble forced me to stop refusing to ask myself the hard questions about what was really going on. As my uncertainty and fear grew, I began a frantic investigation into my wife's recent activity plans and associations. I traced the origin of her emails to find that she wasn't in Arizona at all. She was in Mexico. I began to see what she was doing and what her intentions were. Although my wife has never endeavored to explain to me why she did this, before long I would learn that my wife had been having a long-running affair with one of her friends in her social group and had left to live with him in Nogales, Mexico. After significant effort, I located my son and initiated legal proceedings for his return to the Hague Convention. For good reason, the Abduction Convention is widely viewed as completely ineffective in Mexico. While I could discuss the various problems in Mexico that prevent the effective implementation of the Abduction Convention there, I feel that doing so in this forum misses the forest for the trees. In my own sincere opinion, our priority should not be to address problems in Mexico that we have very little control over. Child abduction to Mexico from the U.S. is as much an American policy problem as it is a Mexican one. Inasmuch as Mexico is cited for failing to take appropriate measures to curb the international abduction of children, the U.S. government is likewise criticized for not taking appropriate measures to protect American children or support American parents in their efforts to recover their internationally abducted children. The proximity and close relationship between the United States and Mexico makes the problem of one country the problems of both, and by extension places the responsibility of addressing the problem on both countries. This type of bilateral cooperation is part of a broadening recognition of the fact that as neighbors, both nations share the responsibility of addressing our problems. American parents rightfully complain that they are alone in dealing with foreign courts and legal systems. The U.S. State Department has a virtual monopoly on information in such cases, but refuses to share this information or act as a vigorous advocate for America's victimized families. There is an explicit conflict of interest between states' goal of maintaining pleasant bilateral foreign relations and assertive and effective advocacy and assistance on behalf of American citizens. Upon being assigned a caseworker at the Office of Children's Issues and having a first conversation with him, I remember thinking to myself, my God, they put the Department of Motor Vehicles in charge of recovering my son. To my subsequent horror, I've come to appreciate just how accurate that initial impression was. All of my entreaties for advice, guidance, or practical information on how I should proceed were immediately rebuked with claims that they could not provide legal advice. When I look back on the way the Office of Children's Issues orientated me on how to handle the abduction of my son, I have very little doubt that they were essentially setting me up for the rapid collapse and failure of the Hague application for my son's return. By not providing me with some very basic and essential facts, they were effectively guiding me down a path that would lead to the fast resolution of the Hague proceedings, but which would also inevitably result in the denial of my son's repatriation. Because such a result leads to the quick resolution of a potential diplomatic incident, they consider such results a form of success and view the American children's loss of their American family and heritage as an acceptable level of collateral damage. It was only through obsessive focus and efforts on my part that I managed to avoid the road that state had laid out for me. In 2009, the Mexican Family Court rendered a decision that blatantly got every issue of fact and law wrong. In contradiction of virtually every piece of evidence, other than my wife's unilateral testimony, the judge denied my son's return to the U.S., claiming that my wife had been in Mexico since October of 2007, rather than the actual date of June 2008, and that I had waited too long to file an application for his return. In order to further prove during my appeal that my wife had provided criminally fraudulent testimony in Mexican courts, I requested that the U.S. State Department obtain copies of her entry and exit records to the United States. In the Kafkaesque conversations that ensued, I escalated this issue to the abduction unit chief, who claimed they could not give me this information because it would violate my wife's privacy, in spite of the fact that we remained legally married and that she had criminally abducted our child to a dangerous third world country. When I asked to then have the entry and exit records for my son, for whom I am the legal custodial parent, I was told that this was not the role that OCI played and that they aren't allowed to give legal advice or assistance. Furthermore, they said, the information I'm looking for would be of no use to me in court because Mexico and the U.S. share a land border that allows for the fluid entry and exit of persons between the two countries. Therefore, they claimed, proving she had subsequently entered and exited the country would not prove the date of the illegal abduction and retention. I couldn't help but wonder if moments after they had just said to me for the 1,000th time that they couldn't give me legal advice, why were they now giving me legal advice? So I asked OCI if they had a Mexican attorney, to which they replied that they did not. But then why were they now telling me that the information I was requesting was of no legal use to me in Mexican courts during my appeal, when it was my own Mexican attorney telling me to obtain this information? At various points throughout this request, OCI told me something to the effect that a decision had been made in my case, sometimes adding that the appeal is now up to me and my attorney. The clear subtext of these statements was, we consider your case closed. We agree with the family court's decision, and we aren't going to get involved or help you undo what we view as the acceptable resolution of your son's abduction case. No matter how unjust the resolution itself may be, the important thing was that an aura of legitimacy had been created around my son's abduction, and a potential diplomatic irritant had been eliminated. We cannot continue to offer up our abducted American children as sacrificial lambs at the altar of pleasant bilateral relations. The U.S. State Department, and by extension, the rest of the U.S. government's unwillingness to invest even the smallest amount of political capital in protecting our children is inconsistent with our values as Americans. Contrary to the idea that abandoning these children helps us achieve our other, more important policy goals, our callous indifference to the plight of our abducted children only serves to bolster the argument of America's critics that our foreign policy is dominated by the interest of American corporations rather than a fundamental respect for justice and human rights. America leads best when it leads by example, and I hope we can continue to do that. Thank you.